All right, good morning. It is May 29th for Senate Judiciary. We have Steve Collier from BBC that here with us just to talk about the House proposal of amendment to Chapter 45. And yeah, the floor is yours. Thanks for being here.
Yeah, thank you so much. Good morning. I just said Steve Collier from the Ministry of Agriculture. It's good to see you all. So there are quite a few changes the House made, but I was planning on focusing on the ones that we think are most important, if that works for you. Most of them we're fine with, don't have an issue with. I think there are two major things that the House did. One was they removed the trespass protection. And the other one was they reinserted the language in the existing law now that allows a plaintiff to prevail if there's a substantial adverse impact on the health, safety, or welfare, or noxious and significant interference with the use of enjoyment property. So it's the trespass issue. We think that the bill that the Senate passed is much better. And I think it's important to remember that this definition of trespass was never intended, at least from our perspective, to insulate farmers from actually trespassing on someone else's land. That would clearly be a violation. Farmer plowed the wrong field. That was a trespass. That could never be acceptable. And that was not the idea. The idea was that because nuisance and trespass are pretty intertwined with land use claims, most of the time, or at least a lot of the time, when the plaintiff sues anyone for nuisance, they also sue for trespass. So a lot of the nuisance claims, like even odor, smell, noise, pesticide use, even though they really align in nuisance, a landowner will often bring it in trespass as well. The Vermont Supreme Court has not found that those sort of tangential interferences are actually a trespass. They have found that it's as an example that pesticide goes onto the neighboring land, that's a trespass, but they left that question open. So the what we were trying to do was only to insulate a farmer from their use of their own land, not for the use of their neighbor's land. But ultimately the House was not comfortable with that change, took it out. At this late juncture, that's probably, in our view, a room for compromise, because we do want to build a consensus on this bill, because we think it's so important to get some protection. So we do think the trespass protection is much better. We think there are a lot of ways it could have been better defined to make it clear what is not covered, but that's not our principal concern with where it can stand now. And just to back up, there was a lot of testimony taken in the House, both in House Judiciary and House Agriculture. And a lot of the pushback on this bill is that it's not necessary. A lot of people say it's not needed. There aren't a lot of lawsuits. It's true, there's only 4 cases that have gone to the Supreme Court in the last 22 years. There are other cases, but what that testimony really highlighted is just how much conflict there is with farms and neighbors. And when you look at the overview of what we're trying to do is to ensure that if farmers are doing everything correctly, they continue to farm. And the backdrop of that is we are losing hemorrhaging farms, really, farmland at a really pretty concerning rate. We talked this earlier about the last 5-year census period, we've lost 11% of our harvested land. The last 5-year census period, we lost 5% of our farms. The last 5 years in calendar years from COVID until now, we've lost 32% of our dairy farms. Dairy is by far the biggest agricultural industry. So we're trying to, instead of having this amorphous standard that we have now, that was built on a bad Iowa Supreme Court decision, trying to create a standard where both farmers and their neighbors know what's allowed and what's not allowed. In that conflict, I mean, even Heather Darby, who's an agronomist with UVM, testified she's a farmer also in the islands. And she's an organic produce and vegetable grower. And she talked about how every time her farm is out spreading chicken manure in the summer, where all the island people are here, that they're yelling at her, screaming at her, throwing sticks to her tractor, really being very aggressive. And she says a lot of the same people who come to her produce stand buying her vegetables. There's not a great, most people, we used to be in a agrarian society, we no longer are. Most people are not familiar with farming. Most people don't. They no longer visit their parents or their grandparents on the farm. Most people don't know what it entails. And there's a lot less tolerance for it than there used to be. Another farmer, I think he's an organic vegetable grower, but he only grows vegetables, testified about how when he has an irrigation pump that he draws from the rivers sometimes during the summer to be able to water his vegetables. And he testified about how people call and complain to the town and wanted to just shut off his irrigation pump because they wanted to swim in the river. Like these kinds of things are common, and they don't usually lead to lawsuit, and that's great. We don't want them to lead to lawsuit, but this is one of those issues where nuisance protection, nuisance doesn't matter at all until you're actually in litigation, and then it's the most important thing to you. Because once you're in that realm, it can be completely devastating to you. It can literally shut you down, but also can curtail your operations in a way that you can no longer farm. So that's the whole import of this law, is to try to create a standard that both neighbors and farmers know what's allowed. And it's not the standard that you created is not easy for farms to meet. It's not like farms can just can do whatever they want. They have to file a whole litany of water quality regulations. They have to follow pesticide regulations, and most importantly, for everything else, they have to follow septic customs standards, proper practices as similar agricultural operators. So under this bill, there's no free pass for farmers. But what there is a standard of compliance. So if a farmer is doing everything that it's supposed to do when it's farming, and believe me, if you all know, a plaintiff has a lot of money, they're going to hire an expert, and they're going to say that a farmer is doing something wrong, even if they're not. So there's still plenty of room for an aggressive plaintiff to try to challenge even the legal protection that you're creating. But at least it's a standard that courts can interpret, and it's an objective standard. For courts are looking objectively at what should be protected, and they're able to interpret that. So that, to me, to us, was the biggest point of this bill, and what the House side did by bringing back the language. And I don't know if you want a paper copy, have it or not, but you have in the House proposal. Does anybody want a paper copy? I have some. Yeah,
We have the House of President.
you do have it. Okay. So the biggest objection that we have is on page 5, and it's on line 17 through 20. The two provisions, the agricultural activity has a substantial adverse effect on health, safety, or welfare, or the agricultural activity has a noxious and significant interference with the use and enjoyment of the neighboring property. These are not nuisance standards. These are standards that were put into our law as it stands in order to overcome the presumption if the farmer could prove it. None of these terms are defined, especially when you look at the adverse effect on health, safety, or welfare. Those are terms that are used to define the state's police power. In the state, meaning the municipality or the state, has the right to regulate behavior to protect the citizenry, to protect its public. Those are terms that are all about public protection. They're about the state taking action, or the municipality or town taking action to protect the public. This has nothing to do with private nuisance actions. Putting these terms in here conflates the whole distinction between private nuisance and public nuisance. If someone is creating a public nuisance, the state, the town, whatever regulatory body has control, that the LURB, or any of those regulatory bodies that have authority, they have the rights as given to them to enforce public nuisance. Private landowners the whole use and enjoyment of your property is not supposed to relate to public nuisance like health, safety, and welfare. I printed out the definition, but just went to Merriam-Webster. You could go to different dictionary, I think, and find literally find a different definition of health, safety, and welfare and noxious for in every dictionary, because they're not well-defined terms. But there's each of the terms, it's just the Merriam-Webster definition, but it's broad and intentional broad because the terms are meant to be far-reaching. Just give you a second to look at those. just for a little context, private nuisance is supposed to be about the substantial and unreasonable use of your enjoyment of your own property. And unreasonable is a key term because that's an objective standard when you're talking about unreasonable. So it's not supposed to be about each and every neighbor or plaintiff's personal sensitivities. It's supposed to be about what is a farm or someone else doing that's creating a nuisance. But when you add in substantial adverse effect on health, safety, or welfare, there's no objective criteria left. There is when it's a public nuisance, which is what health, safety, and welfare is supposed to be about, is public. And if there's a broad-based impact on the public, the state and municipalities absolutely have a right to intervene. And that's true under the proposal that you passed, and also would remain true under the proposal that the House passed. But when you talk about subjectively health and safety and welfare, as an example with health, private nuisance is not supposed to be about an individual plaintiff's sensitivities. I mean, are farmers supposed to not grow crops if their neighbor has allergies? Is a farmer not supposed to be able to make noise during the day if their neighbor has insomnia? I mean, there is no reason to bring the concept of health into private nuisance for a use and interference with the property.
So I want to clarify, just to make sure that we're on the same page, that it's not that this allows a plaintiff to prevail. As far as I'm understanding it, it's as to whether or not the nuisance protection will exist or not. And so if plaintiff would have the burden of proving by preponderance of the evidence that there's a substantial adverse effect on health, safety, or welfare. And then if they're able to pierce that shield, then they have to go on and prove the elements of the actual nuisance. So it's, as I'm understanding it, it wouldn't allow the plaintiff to prevail just if they were to prove what you're describing here.
So the way this is phrased, as I understand it, is that the first thing that plaintiff has to do is prove that a farmer under the new standard is prove that a farmer is doing something wrong. So that involves any one of those. They're not performing pursuant to a generally accepted agricultural practices. So they have to do that, and then they have to prove also the substantial use and enjoyment of property. But under subsection C, this section that was added back in, the protection doesn't apply. So even if a farmer's doing everything right, the protection doesn't apply if they're being negligent. Or under the House's proposal, the protection, even if a farmer's doing everything right, would not apply if the plaintiff can show a substantial adverse effect on health, safety, or welfare. So this disrupts the whole standard. The idea behind this language was, instead of each individual court and each individual neighbor deciding what's appropriate, is the legislature sets the standards. So that's what you've done by shifting the burden to the plaintiff and by saying what a farmer wants to do to not be liable for nuisance. But this upsets that balance. This says even if the farmer's doing everything all right, the neighbor says, I have insomnia and I can't sleep. The only time I can sleep is during the day, and this farm next to me is making a lot of noise. That suddenly is a factual question that a court can't rule on without a trial, because those are factual questions that a court can never decide just based on the pleading. So that means you're going to have a trial to subjectively determine whether the noise is creating a substantial adverse effect on the health. And that's problematic for a couple of reasons. Nuisance has nothing to do with health. It's about the use and enjoyment of your property. If you're actually injuring somebody, that's a personal injury claim. If you are doing something, if you're poisoning somebody's drinking well and you cause injury to them, that's a personal injury claim. That's not a nuisance claim or a trespass claim. So this is conflating public nuisance and private nuisance, and it's changing the whole calculus of what matters. I don't even know, what does safety matter? What is it you can do on your own property as a farmer that's jeopardizing the safety of your fields? That's a police function. That's a state function. The only thing I could come up with is traffic. You've got a lot of heavy trucks coming in. You've got a farm stand with a lot of cars coming in, so there's a lot of traffic on the road. Is that creating a safety for your hazard for your neighbor because you're increasing traffic? That, I mean, that's the kind of thing that should be under an objective standard, not from a neighbor coming to testify that they have young kids and their young kids playing in the yard, and all of the traffic from the farm stand next door is causing a safety hazard for them. But by adopting this amorphous standard and not defining it, it's not defined in any way. So that has to be decided by a judge or jury, and it has to be decided based on testimony. So you just kind of the simplicity of trying to define the standard, if you incorporate these vague, ambiguous, and subjective terms, sort of blow up the whole standard, so that even if there's a claim that just has a neighbor saying, my health is impacted by this, that's not something a court can discount without judging credibility, which requires a trial. So you're bringing in all of these other standards that have nothing to do with nuisance. And they are in current law now. That's part of the reason the law is bad. Part of the law is bad now because it has all these standards that a farmer has to prove that shouldn't be part of the calculus, but it also has this rebuttable presumption standard. And perhaps the most poignantly is with the use of the noxious and significant interference. We just had a trial court in Vermont say that the smell of manure was noxious. And they didn't have to find that because they found that the nuisance protection didn't exist under that case. But this manure pit was a half a mile from the plaintiff's home, and the court said it was noxious. And the court said that based on the plaintiff saying it smelled bad and they couldn't enjoy their home, and the neighbor saying it smelled bad. And they didn't show the farm was doing anything inappropriate with its manure management. As we talked about before, there's a lot of regulations about manure management, including we require farms to have 6 months of storage, 180 days of storage, so that they're not spreading in the winter. And that's a water quality requirement. So this farm, there's no evidence the farm was doing anything wrong with its manure, or that it smelled any different than any other dairy farm. But a court found that it was noxious and enjoined the farm from smelling. The problem with that is you can't stop anyone from smelling. So it creates a situation where any farm, Heather Darby even testified about spreading chicken manure out on the islands during the summer for organic vegetables. Chicken manure stinks worse than cow manure. I think most people agree with that. But if a neighbor can say that you're spreading in chicken manure is noxious, a court can enjoin that. And you could literally shut down Heather Darby's farm as an organic produce grower in the islands. I don't think anyone wants that. But by incorporating these subjective and undefined and amorphous claims, that's what you leave up to a judge, which isn't fair to the judge either. How is a judge supposed to, sorry.
These two terms are in current law, yes?
Yes.
Have these farms been threatened to be shut down under current law?
There's an injunction saying that the farm's manure can't smell, and that the farm could be held in contempt. It has been held in contempt for not for the smell, but for the water. Absolutely. Yeah. You can issue an injunction to stop something, then you can enforce that. And if there's a way to remediate it, if you can stop the smell, then that would be okay. But if there's no way to stop the smell, then ultimately you're just in violation of the court's order, and that can become with stricter and stricter and harsher penalties.
I guess my question is this happening frequently where farms are being shut down under current law?
The only injunction I'm aware of about the smell of manure is that one that I mentioned. Right. And that's why, everyone says this isn't a problem. It's a problem when it becomes one. And more importantly, the law should make sense to be applied. So if you can't tell me what noxious is, it shouldn't be a standard. And I don't think it's easy to tell what noxious is. It's not defined. It's poorly defined even in case law, but it's not typically even an element of private nuisance. So if you're going to add terms, the courts, when they look at terms that the legislature uses, they can't discount them as irrelevant. They have to assume that they had meaning.
Well, we're not adding terms, these exist currently.
Right, and part of the reason the law should be changed, in our opinion, it's not well defined. And if you can't define a term, health, safety, or welfare, or noxious, if you want to define it, then define it. What does that mean? I mean, is the smell of manure noxious? Is it only noxious under certain circumstances? Is it noxious with certain conditions? But now the issue is you leave it to every individual plaintiffs and every individual judges or juries subjective determination. If you want to have good laws, ones that people can follow, you want them to make sense. If you read noxious, it's anyone's guess how that's going to come out, which is also bad for litigation because if lawyers can't advise their clients about what a judge or jury will do with a term, it's difficult to determine whether to bring it. But if you can literally subjectively say that manure is noxious to me and that can sustain the claim, then you're putting farms at risk. And if in our view, if farms manure management under current law isn't adequate, that's something we should be talking about. And that's something we should be talking about as state standards, not leaving up to the individual subjectivity of each farm and each neighbor, leaving them vulnerable to potentially drastic consequences. I mean, you wouldn't think that people would be yelling at a farmer, tilling the fields and throwing sticks at the farm's tractor when they're tilling the fields. You wouldn't expect that to happen, but it is happening. And the point of all that conflict is any one of those conflicts can lead to a nuisance claim. And when you have a lot of money, it's pretty easy to bring a nuisance claim. Most people don't want to do that, which is wonderful. But the law should be the backstop to what we think is acceptable and what's not acceptable. And with lawyers looking at those terms, health, safety, welfare, and noxious, can't define them with any certainty, how do we expect citizens to be able to define them with any certainty? And they can't define them with any certainty, and that means it's a roll of the dice anytime anybody comes to claim. And that's what we're trying to prevent. Is we don't want this. We want real, defined, enforceable standards. We're not saying farmers should be able to do whatever they want with their farm. Quite the contrary. There's a litany of rigorous regulations about what they have to do with their manure. If they're not doing those things correctly, they're subject both to administrative enforcement and also to private nuisance action. But if a farm is doing everything we tell them they have to do with the manure, and then a neighbor doesn't like the smell, I mean, that's policy choice. If you think it's more important if the neighbor doesn't have to smell manure, then the farm can spread manure. And keep in mind, you can't grow food without nutrients. So manure is a waste, but it's also essential to growing crops. So that's why vegetable farmer is spreading, even though they don't generate their own manure, they have to report it because you can't grow food without nutrients. So manure is like an essential piece. Use fertilizer instead, but you need to have nutrients or you don't grow food. So the question is, do we want to leave that to somebody's particularly sensitive olfactory smell? Or do we want to define standards that farms and neighbors can apply and the judges and juries can then apply based on some sort of objective criteria rather than somebody's own personal circumstances? That's not what private nuisance is not supposed to be about remediating any harm in any fields. It's supposed to be about remediating an objective, which means it's offensive to an ordinary person. It's not to an individual. So this is great if you're a plaintiff and you want to bring a lawsuit. No question. It's perfect because you've always got an argument. If you want to tell farms what to do and tell neighbors what farms are required to do, then this upsets that construction.
Well, I just want to make sure that clear that you're testifying that the way in which a plaintiff can overcome the nuisance protection would be analyzed as a subjective standard, but the objective standard for actually proving the nuisance claim still exists.
Correct, for nuisance itself, but in this language, because if you look at subsection C, it says the nuisance protection for an agricultural activity provided for under subsection A of this section. So that's the nuisance, that's the generally accepted ag practices. That protection does not apply when if you show negligence, if you show substantial adverse substantial adverse effect on health, safety, or welfare, or the noxious and significant interference. So even if the farm's doing everything right, there's no nuisance under the protection. You've got the subjective standard that can be applied.
So if there's no nuisance beyond the nuisance protection categories, then I'm not sure how a plaintiff would be able to prevail because they're getting past this initial protection that exists. They still have to approve the objective standard for a nuisance plan?
So the way this is, so keep in mind, there's nuisance under, the whole point of right to farm is to provide protection from nuisance claims. And so it's an alteration of the standard nuisance protection. And most people aren't making a living from homes in ways that cause odors or smells or noise or traffic. Farms do. So the point of right to farm is to insulate them from ordinary nuisance actions if they meet certain criteria. That's what you're building and shifting the burden and creating the standard. But this extra language that was put back in allows the plaintiff to overcome the nuisance protection, even if the farm is meeting all of the generally accepted agricultural standards. So yes, a plaintiff would still have to prove that there is even a nuisance, but the farm, even if the farm is doing everything correctly, they can overcome that by showing an adverse effects on health, safety, or welfare. So you lose the objective standard once you get to the point. This subsection C doesn't even matter if a farm's violating law. If a farm's doing something wrong, you never get the subsection C, because the court just says there's no nuisance protection. Like if a farm is not following generally accepted ag practices, they don't get any protection. So then the only question is, are they creating a nuisance? And that's the substantial and unreasonable use and enjoyment of your property. But what subsection C does, it says even if the farm's doing everything right, then a plaintiff can still overcome that. So it's creating a path to prevail against the farm when they're meeting all of their generally accepted standards. And it's creating, most troublingly, it's creating an undefined subjective path. So this means get a trial. Anytime anybody brings a case and says, I can't sleep, I have allergies, my health is affected, and you can't decide that's not true without a trial. That's something that a court has to decide, and you can't decide disputed material facts without a trial. So that means it's not enough to just show a farm is doing something wrong. Even if you can't show a farm is doing anything wrong, you can just say it's bothering me. And that is not what private nuisance is about. When you look at private nuisance, it doesn't talk about health, safety, or welfare. That's public nuisance. Private nuisance is about the substantial and unreasonable use of interference with use and enjoyment of property. And this is just conflating different standards and making it, again, vague and ambiguous instead of, relatively clear. And
So these pathways to overcome the nuisance protection, they exist in current law, right?
the negligent one doesn't, but the second two do. They're how you overcome the presumption if a farm can prove that it's entitled to protection.
It's a farm, and so this is changing the burden. This language that we have before is changing the burden from the farmer to the plaintiff. Right?
Well, not on that piece, because currently the farm has to prove they're entitled to the nuisance protection, and then if they do, the plaintiff can overcome. So right now it's a rebuttable presumption. The farmer has to prove that they're doing everything right, and then if they do, they get the nuisance protection, and the plaintiff can overcome it. So the plaintiff has the burden in current law for the substantial adverse effect on health, safety, or welfare, or the not just enjoyment. But that doesn't even come into play unless the farmer proves that they get the defense. So this is still this is still the plaintiff's burden. But the problem with it is it creates this subjective, ambiguous standard that's not defined. So it really isn't related to nuisance supply. If someone is interfering with the public health, safety, or welfare, the state can absolutely bring public nuisance claim. And if that's happening, but that means it's affecting the public more generally than one property owner who doesn't like something. And that's the key distinction. No one is saying that state or municipality shouldn't be able to abate a public nuisance. And they can do that now. They can do that in the future. They can do that with this change. But this is giving a private landowner owner the ability to say what's subjectively affecting them, not the public, them. And they can prevail on a private nuisance action if they say their welfare is impacted. What does that even mean? Their welfare is impacted. If you want to create a standard like this, from our perspective, it should at least be clear what's protected and what's not. Instead, right now, you just have the same situation where any plaintiff can go into any court, and there's no way for a judge to say this doesn't meet the criteria if you're bringing a basic claim to say my health is impacted. And this isn't about someone's health. Health is a personal injury. If you hurt somebody, that's a personal injury. This is about use and enjoyment of property. And it's supposed to be an objective test, not a subject that it's like, in law school, you learn about the eggshell plaintiff. If you assault somebody by hitting somebody, that's an assault. And if it just so happens that they have a really thin skull and you punch them and the cranium caves in and they have serious injury or die, that's on you as the assailant. You take the victim as you find them in both civil and criminal law, but that's not true with property claims. With property claims, it's supposed to be about, for nuisance claims, it's supposed to be about an objective. So it's unreasonable. It's not that it's unreasonable to the neighbor, it's unreasonable to a reasonable person. But this arguably, when you say substantial adverse effect on health, safety, or welfare, that's only about the plaintiff. It can't be about the public because it's the plaintiff who's bringing the claim. So then you make it about that individual plaintiff and their individual sensitivities, which is not what property law is supposed to be about. It's not supposed to be about your individual allergies or your individual sensitivity to noise. It's supposed to be an objective standard that would be unreasonable to everyone. So by building this in, you're just creating another layer that basically requires farmers to take their neighbors as they find them instead of whether their activities are objectively reasonable. And so it severely undermines the protection. If the goal is to tell farmers what they have to do and tell neighbors what farmers have to do, then shifting the burden and creating the definition does that. This undoes a lot of that because it just creates a subjective standard that's based on the individual plaintiff's opinions, feelings, which all may be perfectly valid, but it's creating a unique standard where it doesn't matter. It becomes more about who's near you as a farm rather than what the farm is doing everything right.
So do you think that the bill that we have now is more harmful than we have in current law, or provides some benefits? Or I guess my question is, do you think that this bill should pass, or do you think that it should die in its current form?
The bill in the House passed form?
Yes.
The House's form bill is better than President. No question. It's what we would like to happen, if it's possible, is to have a conference committee where there can hopefully be some consensus, and perhaps there could be an exchange of trespass protection, which the Senate passed 25-5. And maybe something like trespass could be exchanged, but take out this subjective standard that again doesn't make it clear. So we think there's plenty of room for consensus. Maybe that's not true. I don't know. But the Senate very strongly passed the version we passed, and the House substantially weakened the protection vis-a-vis farmers. So what we'd like to do is see some consensus and compromise. But I know timing is an issue. I know that's not simple. There's no question the House version is better than current law because it does put the burden on the plaintiff where it belongs. But this language, a lot of our concern about the current language is you can't even easily dispense with frivolous suits because of the whole facts. There's so many factual issues created in current law. And all you have to do is say something that means to basically requires trial. This added language, which is already in current law, but was already part of the problem, keeps that issue going. And that's unfortunate. You created a pretty clean standard. And when you still created, plaintiff under the version that you passed still has many avenues for relief. But under the House version, it really makes it challenging to dispose quickly of even a frivolous. So that's ideally, we'd love to see a compromise on these issues. That's not possible. I think the law is better. It's definitely better than the current version. But it's hard to not make it clear. The whole point of this exercise was let's create a judicial standard. And these vague terms, and especially, you've got a court who found the smell of manure is noxious. That's now precedent in the state of Vermont. So you're much better stead now as a plaintiff. I don't know that people thought about challenging the smell of the air before in Vermont because we're a dairy farming state, we're a farming state. But now you've got a court that said a manure pit a half mile from a neighbor's house smells, and you can't do that. But there's no remedy for the farmers to do that. So if the legislature is okay with saying, yeah, manure smells, you can enjoy that. And I think we've got to kind of look at our broader commitment to farming. And that's an untenable standard. And we don't want Heather Darby's produce farm to be shut down because she's spraying chicken blood. We don't want the farmer who testified about his irrigation pump not being able to irrigate his crops because people want to swim in the river. So it's just, those things are not likely, but they happen. And in this case, they did happen. So our position is if you want to regulate the smell of manure, let's do so thoughtfully and reasonably in a way that farmers can comply, but not just leave it up to every individual neighbor to judge about it.
What was the name of the case regarding the smell?
So you heard all about it, you heard mostly about the water, just every point molding versus enforcement belts.
That was about the smell.
Oh, most of the suit was about water, tile drainage and water, nuisance and trespass, but smell was part of that lawsuit. And the court found that the smell of the manure was noxious, found that it created nuisance and enjoyed it.
Yeah, I just so I'm straight on this, Steve. And I'll be using your words. So it appears we do it side by side, to vote in the Senate and House to remove the Republican assumption. But if I understand you correct, by reinserting or bringing this back in lines to the agricultural activity and through the once again the noxious is significant. By doing that, even though the above over assumption had been removed, in your opinion, does that appear as though that it basically places it back in there?
I wouldn't call it a rebuttable presumption because the burden is always on the plaintiff, but absolutely right that it does the same thing. Like even if a farm is entitled to nuisance protection because they're doing everything right, then a plaintiff can still overcome it. They just have if the farm's doing everything right, then the plaintiff is a higher burden, but it's also a different and subjective and undefined burden. So yeah, it changes the whole balance of the goal of this legislation was if a farmer is doing everything according to accepted customs and standards and practices and following all the law, then they should have protection. And this language overcomes that and a really unclear one.
Right. And we're not here to protect those agricultural specialists who are in violation of Vermont state law. However, saying that, I do have concern about the noxious odors, whatever else it is, ever since a very committed business that we all realize that manure is not a bad process. Right. It's pretty much a bad general accepted practice that the helps absolutely less than things. Right.
Yeah, it was a bit shocking, honestly, to have the smell of manure joined. Now I can see it depending on if the manure is being mismanaged or if it was being spread in the wrong places or if it was not meeting setbacks. There's a lot of requirements, but when there's no evidence that the farm was mismanaging the manure. And part of that, which is really concerning, is we require the farms, the manure smells worse because of the state, because we require them to store it for 6 months, because of some of the practices they do, which is great for water quality, like liquid manure you can inject into the soil so it doesn't run off as much, which is great. But it smells more when you do it that way. And you use drag lines so there's all of these management techniques which are beneficial in so many ways. And here's the thing, it's the subjective standards. It's an individual plaintiff can say, I can't go outside and eat at my picnic table when I'm here for the summer because I don't like the smell. And there's no great way to measure smell. It's very subjective. And there's no question that manure can smell. And when it's being agitated, it can smell pretty intensely in short periods. But that is leaving the whims, leaving farm viability to the whim of a neighbor is concerning to us. Requiring farms to manage things appropriately is not at all concerning to us. We support that. But when farms doing everything right, and it can be severely impacted because of an individual subjective whim of a neighbor, that's concerning. Keep in mind, if a farm's creating a public nuisance, they can be stopped, and they should be. So this is just about, do we allow individual subjective feelings to dictate how farms can farm?
I'm fully familiar with that, right? Yeah, I'm just,
Yeah. These are important issues. I don't mean to trivialize them in any way. It's just that farms are already so vulnerable to so many things. And nuisance is not normally one of them, but like I said earlier, this is one of those issues that it's irrelevant until it's omnipotent, omnivorous. It's everything once it happens. And if you don't have a legal standard that you can defend yourself on, then you're very, very vulnerable. That's all we want, is we want a standard that says what farms can do.
Just trying to not ignore it, yeah.
No, no.
Through the case.
No.
As fast as I can, while also listening. Committee, any other questions or comments? Any further testimony?
No, I don't think so. We really, we appreciate all the time and attention taken to this issue and the House as well. It's really been a lot of testimony, and a lot of it is, to us, it's reemphasized the importance of gaining this clarity, because we know about a lot of conflict, but we learned about a lot of conflict we weren't even aware of. So setting the standard and giving farms guidance about when they're safe and when they're not, we really think is critically important. It won't impact many, but when it's there, it's really important to have the thought. So I think even if you chose to go to conference in Newburgh, and the House was really resolute about wanting to be able to overcome the standard, and at least it should be defined. It's health, safety, welfare, and not just that's not defined. And that's making it about subjective experience instead of objective criteria. So if you want a plaintiff to be able to overcome the burden, we don't. If a farm's doing everything right, because we think there's plenty of pattern. But if you do want to create that ability to overcome the protection, even when a farm's meeting all the requirements, it at least ought to be clear what they have to do. And health, safety, and welfare in the broadest terms imaginable. And leading it to subjective experience is just it's undoing a lot of the good by creating a standard. Thank you. Yeah, thank you so much.
Hey, what, or we need a few minutes and let's figure this out after the pool.
Either or, see, certain comment, or that's in version. Process. I look forward to one time for a junior festival in Eastburg, telling all of this bill here, that'll go to everybody else except farmers. So, I mean, we can discuss that, so that we have varying opinions here. I have concerns about the bill. I'd like to make one last attempt, so that we get it corrected in 1 month.
I'm happy to confer with the House. I think it's a step forward. And, it's either better than current law. See how it plays out. We have more time to read more testimony and think more about it. We'll do things and see forward.
There's also 2 other members of the committee that are here. There's one more thing I want to meet for. Figure out where I'm meeting. So I'll be, straw polling the other two and figure it out from there. Make a decision for our, after we get more time, so we're gonna be on the floor.